senators to convey to their constituents that they're listening, that they're in attendance, that they're moved by not one side or the other, but all the information. Garrett, is anyone in that body expressing frustration?
Oh, absolutely. I mean, we've had the sympathies of a lot of these senators, and in fact, some, I will say, have gone out of their way to make themselves more available at the places where we can be. The basement of this building, the Capitol subway basement, is one of the few spots where we've not seen the traditional access really get throttled back. So, I mean, we're all kind of working on the same page here, but it is incredibly frustrating, I think, to both groups.
Garrett Haake, thank you. Let's listen into the benediction as they start their day.
Listen up, senators. With the assuring awareness of your powerful involvement, may they strive to have a clear conscience in whatever they do for you and country. Lord, help them remember that listening is often more than hearing. It can be an empathetic attentiveness that builds bridges and unites. May our senators not permit fatigue or cynicism to jeopardize friendships that have existed for years. At every decision point throughout this trial, may they ask, which choice will bring God the greater glory? We pray in your mighty name. Amen.
Amen.
Please join me in reciting the Pledge of Allegiance to our flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Senators will please be seated. If there is no objection, the journal of proceedings of the trial are approved to date. The Sergeant-at-Arms will make the proclamation.
Hear ye, hear ye, hear ye. All persons are commanded to keep silent on pain of imprisonment while the Senate of the United States is sitting for the trial of the articles of impeachment exhibited by the House of Representatives against Donald John Trump, President of the United States.
Mr. Chief Justice.
Majority Leader is recognized.
It's my understanding the schedule today will be similar to yesterday's proceedings. We will plan to take short breaks every 2 or 3 hours, and we'll accommodate a 30-minute recess for dinner, assuming that is needed.
Thank you. Pursuant to the provisions of Senate Resolution 483, the managers of the House of Representatives have 16 hours and 42 minutes.
Allow me to interrupt for just one moment because those involved, whether you're a consumer of journalism or a practitioner, we are just learning, thanks to word from Judy Woodruff, of the death of Jim Lehrer, longtime co-anchor of the MacNeil-Lehrer NewsHour on PBS. A terrific guy with such a quirky intellect and such a love of our trade. Jim Lehrer has died. Back to Adam Schiff on the Senate floor.
You have a lot of work at the court, necessitating our beginning in the afternoon and going into the evening. But I also want to again take this opportunity to thank the senators for their long and considerable attention over the course of the last 2 days. I'm not sure the Chief Justice is fully aware of just how rare it is, how extraordinary it is for the House members to be able to command the attention of senators sitting silently for hours, or even for minutes for that matter. Of course, it doesn't hurt that the morning starts out every day with a Sergeant-at-Arms warning you that if you don't, you will be imprisoned. It's our hope that when the trial concludes, and you've heard us and you've heard the President's counsel over a series of long days, that you don't choose imprisonment instead of anything further. 2 days ago, we made the case for documents.
And to my viewers, I would like to comment and weigh in on what he just said. The primary purpose for that is to maintain law and order in the stability of a trial. It's no disrespect upon one particular person, no more so than the other. But we can't afford to have a free-for-all in the middle of a proceedings this rare and this significant in the eyes of not just the American people, but the eyes of the world. We can't afford to have some sort of free-for-all erupt in the center of a trial this substantial. Keep in mind, our trials over here are different than the trials over in Europe. Over in Europe, they're allowed to scream and holler and yell at one another and stand up and voice their opinions. And our proceedings are different over here with our courts than what they are over there. And it's not that ours is any better or theirs is any worse or vice versa. It's just that this is the way that we believe that our system should be run during the proceedings of a court proceedings, especially one this serious, pertaining to orderly. And I mean, even the Bible that we give an oath, the majority of us give an oath to, who are public servants to the public, that things are to be conducted in a orderly fashion. And if they're not conducted in a orderly fashion, then odds are God, the Creator, is not part of that proceedings. You know, some may debate and say, well, how do you know that the American court system is more fair than the system over in Europe, or the system over in Russia, or the system over in China, or the system over in South America, or in other parts of the world? We base our beliefs off of how things have been conducted in a orderly form pertaining to the Bible. That's how we have projected things to be orderly whenever you are involved in such of a procedure such as this. You don't want people jumping up and down. You don't need people screaming and hollering. You don't need people voicing their opinions by becoming louder or disrespectful to each other. You need to do things in an orderly fashion. That's what our practices here in America are. And they're supposed to be done that way, not only in a higher court pertaining to the next thing to a military court, but they're supposed to be done that way even in a lower court pertaining to a county court or even a state court where the state is trying to do something pertaining to someone who has broken the law. Things are supposed to be done in an orderly fashion. Let's get back to the business at hand. And I do apologize for breaking in, but I want to make reference that I found it to be very touching that they began with a formal prayer and the pledges of allegiance pertaining to our American flag. That was extremely touching for the Senate to do that.
For witnesses in the trial. Yesterday we walked through the chronology, the factual chronology at some length. Today we'll go through Article 1, the constitutional underpinnings of abuse of power, and apply the facts of the President's scheme to the law and Constitution. And here I must ask you for some forbearance. Of necessity, there will be some repetition of information from yesterday's chronology, and I want to explain the reason for it. You have now heard hundreds of hours of deposition and live testimony from the House, condensed into an abbreviated narrative of the facts. We will now show you these facts and many others and how they are interwoven. You will see some of these facts and videos, therefore, in a new context, in a new light, in the light of what else we know and why it compels a finding of guilt and conviction. So there is some method to our madness. Tomorrow, we will conclude the presentation of the facts and law on Article 1, and we will begin and complete the same on Article 2, the President's unconstitutional obstruction of Congress. The President's counsel will then have 3 days to make their presentations, and then you will have 16 hours to ask questions, and then the trial will begin. And then you will actually get to hear from the witnesses yourself, and then you'll get to see the documents yourself, or so we hope, and so do the American people. And after their testimony and after we've had closing arguments, then it will be in your hands. So let's begin today's presentation, and I yield to House Manager Nadler.
Good morning, Mr. Chief Justice, Senators, my fellow House managers, and counsel for the President. This is the third day of a solemn occasion for the American people. The articles of impeachment against President Trump rank among the most serious charges ever brought against the President. And as our recital of the facts indicated, the articles are overwhelmingly supported by the evidence amassed by the House, notwithstanding the President's complete stonewalling, his attempt to block all witnesses and all documents from the United States Congress. The first article of impeachment charges the President with abuse of power. President Trump used the powers of his office to solicit a foreign nation to interfere in our elections for his own personal benefit. Note that the act of solicitation itself, just the ask, constitutes an abuse of power. But President Trump went further. In order to secure his favor from Ukraine, he withheld two official acts of immense value. First, he withheld the release of $391 million in vital military assistance appropriated by Congress on a bipartisan basis, which Ukraine needed to fight Russian aggression. And second, President Trump withheld a long sought after White House meeting, which would confirm to the world that America stands behind Ukraine in its ongoing struggle. The President's conduct is wrong. It is illegal. It is dangerous.
Yes.
And it captures the worst fears of our founders and the framers of the Constitution. Since President George Washington took office in 1789, no president has abused his power in this way. Let me say that again. No president has ever used his office to compel a foreign nation to help him cheat in our elections.
Ever.
Prior presidents would be shocked to the core by such conduct, and rightly so. Now, because President Trump has largely failed to convince the country that his conduct was remotely acceptable, he has adopted a fallback position. He argues that even if we disapprove of his misconduct, we cannot remove him for it. Frankly, that argument is itself terrifying. It confirms that this president sees no limits on his power or on his ability to use his public office for private gain. And of course, the president also believes that he can use his power to cover up his crimes. That leads me to the second article of impeachment, which charges that the president categorically, indiscriminately, and unlawfully obstructed our inquiry, the congressional inquiry into his conduct. This presidential stonewalling of Congress is unprecedented in the 238-year history of our constitutional republic. It puts even President Nixon to shame. Taken together, the articles and the evidence conclusively establish that President Trump has placed his own personal political interests first. He has placed them above our national security, above our free and fair elections, and above our system of checks and balances. This conduct is not America first, it is Donald Trump first. Donald Trump swore an oath to faithfully execute the laws. That means putting the nation's interests above his own. And the president has repeatedly, flagrantly violated his oath.
And I just want to stress that if what we're talking about is not impeachable, then nothing is impeachable. This is precisely the misconduct that the framers created a constitution, including impeachment, to protect against.
All of the legal experts who testified before the House Judiciary Committee, those invited by the Democrats and those invited by the Republicans, all agreed that the conduct we have charged constitutes high crimes and misdemeanors. Professor Michael Gerhardt, the author of 6 books and the only joint witness when the House considered President Clinton's case, put it simply: if what we're talking about is not impeachable, then nothing is impeachable. Professor Jonathan Turley, called by the Republicans as a witness, agreed that the articles charge an offense that is impeachable. In his written testimony, he stated, "The use of military aid for a quid pro quo to investigate one's political opponent, if proven, can be an impeachable offense." Close quote. Thus far, we have presented the core factual narrative. None of that record can be seriously disputed, and none of it will be disputed. We can predict what the president's lawyers will say in the next few days. I urge you, senators, to listen to it carefully. You will hear accusations and name-calling. You will hear complaints about the process in the House and the motives of the managers. You will hear that this all comes down to a phone call that was perfect, as if you had not just seen evidence of a months-long government-wide effort to extort a foreign government. But you will not hear a refutation of the evidence. You will not hear testimony to refute the testimony you have seen. Indeed, if the president had any exculpatory witnesses, even a single one, he would be demanding their appearance here instead of urging you not to permit additional witnesses to testify. So now let me offer a preview of the path ahead. First, we will examine the law of impeachable offenses with a focus on abuse of power. That will be the subject of my presentation. Then my colleagues will apply the law to the facts. They will demonstrate that the president has unquestionably committed the high crimes and misdemeanors outlined in the first article of impeachment. Once those presentations are concluded, we will take the same approach to demonstrating President Trump's obstruction of Congress, the second article of impeachment. We will begin by stating the law. Then we will review the facts, and then we will apply the law to the facts, proving that President Trump is guilty on the second article of impeachment as well. With that roadmap to guide us, I will begin by walking through the law of abuse of power. Here I'll start by defining the phrase in the Constitution, high crimes and misdemeanors. When the framers selected this term, they meant it to capture, as George Mason put it, all manner of great and dangerous offenses against the nation. And in contemporary terms, the framers had 3 specific offenses in mind: abuse of power, betrayal of the nation through foreign entanglements, and corruption of elections. You can think of these as the ABCs of high crimes and misdemeanors: abuse, betrayal, and corruption. The framers believed that any one of these standing alone justified removal from office. Professor Noah Feldman of Harvard Law School explained this well before the House Judiciary Committee. Here is his explanation of why the framers created the impeachment power.
The framers provided for the impeachment of the president because they feared that the president might abuse the power of his office for personal benefit to corrupt the electoral process and ensure his re-election, or to subvert the national security of the United States.
That is the standard as described by Professor Feldman. It is correct. And of course, where all three of these concerns appear at once, abuse, betrayal, and corruption, that is where we have the strongest possible case for removing a president from office. Later on, we will apply this rule to the facts. Abuse. We will show that President Trump abused his power when he used his office to solicit and pressure Ukraine to meddle in our elections for his personal gain. Betrayal. We will show that he betrayed vital national interests, specifically our national security, by withholding diplomatic support and military aid from Ukraine, even as it faced armed Russian aggression. Corruption. President Trump's intent was to corrupt our elections to his personal political benefit. He put his personal interest in retaining power above free and fair elections, and above the principle that Americans must govern themselves without interference from abroad. Article 1 thus charges a high crime and misdemeanor that blends abuse of power, betrayal of the nation, and corruption in elections into a single unforgivable scheme. That is why this president must be removed from office, especially before he continues his effort to corrupt our next election. The charges set forth in the first article of impeachment are firmly grounded in the Constitution of the United States. Simply stated, impeachment is the Constitution's final answer to a president who mistakes himself for a king. The framers had risked their freedom and their lives to escape monarchy. Together, they resolved to build a nation committed to democracy and the rule of law, a beacon to the world in an age of aristocracy. In the United States of America, we, the people, would be sovereign. We would choose our leaders and hold them accountable for how they exercise power in our behalf. In writing our Constitution, the framers recognized that we needed a chief executive who could lead the nation with efficiency, energy, and dispatch. So they created a powerful presidency and vested it with immense public trust. But this solution created a different problem. The framers were not naive. They knew that power corrupts. They knew that republics cannot flourish and that people cannot live free under a corrupt leader. They foresaw that a president faithful only to himself would endanger every American. So the framers built guardrails to ensure that the American people would remain free, and to ensure that out-of-control presidents would not destroy everything that they sought to build. They imposed elections every 4 years to ensure accountability. They banned the president from profiting off his office. They divided the powers of the federal government across 3 branches, and they required the president to swear an oath to faithfully execute the laws. To the framers, the concept of faithful execution was profoundly important. It prohibited the president from exercising power in bad faith or with corrupt intent, and thus ensured that the president would put the American people first, not himself. A few framers would have stopped there. This minority feared vesting any branch of government with the power to remove a president from office. They would have relied on elections alone to address rogue presidents. But that view was decisively rejected at the Constitutional Convention. Convening in the shadow of rebellion and revolution, the framers would not deny the nation an escape from presidents who deemed themselves above the law. Instead, they adopted the power of impeachment. In so doing, they offered a clear answer to George Mason's question, shall any man be above justice? As Mason himself explained, some mode of displacing an unfit magistrate is rendered indispensable by the fallibility of those who choose, as well as by the corruptibility of the man chosen. Unlike in Britain, the president would answer personally to Congress and thus to the nation for any serious wrongdoing. But this decision raised the question, what conduct would justify impeachment and removal? As careful students of history, the framers knew that threats to democracy can take many forms. They feared would-be monarchs, but also warned against fake populists, charismatic demagogues, and corrupt kleptocrats. In describing the kind of leader who might menace the nation, Alexander Hamilton offered an especially striking portrait. Mr. Schiff read this portrait in his introductory remarks, and it bears repetition. When a man unprincipled in private life, desperate in his fortune, bold in his temper, known to have scoffed in private at the principles of liberty, when such a man is seen to mount the hobby horse of popularity, to join in the cry of danger to liberty, to take every opportunity of embarrassing the general government and bringing it under suspicion, to flatter and fall in with all the nonsense of the zealots of the day, it may justly be suspected that his object is to throw things into confusion, that he may ride the storm and direct the whirlwind.
Wow. Let's back that up.
Hamilton, that
if you'll take notice in when that was come into document, right down there on the bottom, it says August the 18th, 1792. You tell me that these people that helped to form our Constitution and our Bill of Rights wasn't geniuses. They sat down and they looked at every crevice and every gap pertaining to the who, the what, the when, and the why. You tell me that these people wasn't clever enough to see through what could have occurred if the wrong person with the wrong motives becomes in power in this seat of presidency. They seen how that it could be very, very manipulative. It may justly be suspected that his object is to throw things into confusion. Which, once more, who's the author of confusion? According to the Bible, Satan is. Throw things into confusion, that he may ride the storm and direct the whirlwind. In other words, try to mastermind something that ultimately he looks like a hero of. In other words, create chaos, create some sort of a crisis, and then come in behind the crisis towards projecting himself as being the hero. It's similar on a smaller scale towards what that they was accusing the individual pertaining to the bombing that happened in Atlanta, towards planting a bomb and then acting like that he was the hero because he found the bomb. That was on a smaller scale pertaining to Mr. Jewell. Okay, Mr. Richard Jewell, the movie that just recently come out. That was on an independent, smaller scale in which the courts hasn't yet confirmed, but the movie has, that Mr. Jewell was truly a hero. Mr. Jewell did not plant the bomb. It was Eric Rudolph that planted the bomb. Not only did he plant the bomb in the Atlanta Olympics, but he also planted the bomb in the clinic, the abortion clinic down there, that I was questioned by the Georgia authorities while I was working in that area, questioned by them directly, not indirectly, but directly, towards how did I feel about that particular occurrence. And of course I come back that two wrongs don't make a right. But the point that I'm trying to make is what Mr. Jewell was accused of is on a smaller scale. Now what we're looking at here is a bigger scale, but it reaches that same type of motive, that same type of inner hidden agenda that they was trying to accuse Mr. Jewell of. This right here is a very, very serious, conniving, manipulative way of a president trying to become a hero because he is directing the whirlwind. You keep in mind, this was written August the 18th, 1792. Tell me that our forefathers, tell me that our founders of this great nation was not geniuses whenever they got to looking at the inner fundamental cracks of what somebody could do if it was the wrong person for the wrong motives. Alexander Hamilton, Hamilton. That is extraordinary that our forefathers would have the insight of being able to foresee that something like that could actually occur towards high treason. And that's what the Democrats are pointing their finger towards Donald Trump doing. And if that be the case, and if they can prove that that be the case, then that man deserves to be rightfully shamed. He rightfully deserves to be disembarred from his position, and he rightfully deserves to be marked as a possible terrorist. I didn't say for sure, but possible terrorist in the highest form. Because we know, and have always known, that the Russian parliament, the Russian so-called government, has always been corrupt. It has always been a sense of slavery in the same form that the Pharaohs was establishing upon the children of Israel during the time that Moses was chosen by God to liberate those people from their bondages. We know for a fact that these type of illegitimate governments that are being run in this type of tyranny form, regardless whether it's Russia, China, or other places throughout the world, down in South America, we know that these type of practices are not only unfair to the rest of their citizens, their civilians, but it's unfair practices across the board that goes all the way back to the ancient biblical Bible era time. Goes all the way back into 2,000, 3,000, 4,000 years before Jesus ever even come onto the scene towards preaching his gospel to the world. This is just, I find this right here to be absolutely mind-boggling. That our forefathers, our builders, our framers, could foresee the vulnerabilities in a democracy to be able to put in place of impeachment. Tell me that this is not the greatest nation in the world. This proves it right here, that it is the greatest nation on the planet.
That he may ride the storm and direct the whirlwind. Hamilton was a wise man. He foresaw dangers far ahead of his time. Given the many threats they had to anticipate, the framers considered extremely broad grounds for removing presidents. For example, they debated setting the bar at maladministration to allow removal for run-of-the-mill policy disagreements between Congress and the president. They also considered very narrow grounds, strictly limiting impeachment to treason and bribery. Ultimately, they struck a balance. They did not want presidents removed for ordinary political or policy disagreements, but they intended impeachment to reach the full spectrum of presidential misconduct that might threaten the Constitution. And they intended our Constitution to endure for the ages. So they adopted a standard meant, as Mason put it, to capture all manner of great and dangerous offenses incompatible with the Constitution. This standard, borrowed from the British Parliament, was high crimes and misdemeanors. In England, the standard was understood to capture offenses against the constitutional system itself. That is confirmed by the use of the word high, as well as by parliamentary practice.
High treason.
From 1376 to 1787, the House of Commons impeached officials on a few general grounds, mainly consisting of abuse of power, betrayal of national security and foreign policy, corruption, treason, bribery, and disregarding the powers of Parliament. The phrase high crimes and misdemeanors thus covered offenses against the nation itself. In other words, crimes against the British Constitution. As scholars have shown, the same understanding prevailed on this side of the Atlantic. In the colonial period and under newly ratified state constitutions, most impeachments targeted abuse of power, betrayal of the revolutionary cause, corruption, treason, and bribery. These experiences were well known to the framers of the Constitution. History thus teaches that high crimes and misdemeanors referred mainly to acts committed by officials using their power or privileges that inflicted grave harm on society. Such great and dangerous offenses included treason, bribery, abuse of power, betrayal of the nation, and corruption of office. And they were unified by a clear theme. Officials who abused, abandoned, or sought to benefit personally from their public trust and who threatened the rule of law if left in power faced impeachment and removal. Abuse, betrayal, corruption. This is exactly the understanding that the framers incorporated into the Constitution. As Supreme Court Justice Robert Jackson wisely observed, the purpose of the Constitution was not only to grant power, but to keep it from getting out of hand. Nowhere is that truer than in the presidency. As the framers created a formidable chief executive, they made clear that impeachment is justified for serious abuse of power. James Madison stated that impeachment is necessary because the president, quote, might pervert his administration into a scheme of oppression, close quote. Hamilton set the standard for removal at an abuse or violation of some public trust. And in Massachusetts, Reverend Samuel Stillman asked, with such a prospect of impeachment, who will dare to abuse the powers vested in him by the people? Time and again, Americans who wrote and ratified the Constitution confirmed that presidents may be impeached for abusing the power entrusted to them. To the framing generation, moreover, abuse of power was a well-understood offense. It took two basic forms. The first occurred when someone exercised power in ways far beyond what the law allowed, or in ways that destroyed checks on their own authority. The second occurred when an official exercised power to obtain an improper personal benefit while ignoring or injuring the national interest. In other words, the president may commit an impeachable abuse of power in two different ways: by engaging in clearly forbidden acts, or by taking actions that are allowed, but for reasons that are not allowed. For instance, to obtain corrupt private benefits. Let me unpack that idea, starting with the first category: conduct clearly inconsistent with the law, including the law of checks and balances. The generation that rebelled against George III knew what absolute power looked like. It was no abstraction to them. They had a different idea in mind when they organized our government. Most significantly, they placed the president under the law, not above it. That means the president may exercise only the powers vested in him by the Constitution. He must also respect the legal limits on the exercise of those powers. A president who egregiously refuses to follow these restrictions by engaging in wrongful conduct may be subject to impeachment for abuse of power. 2 American impeachment inquiries have involved claims that a president grossly violated the Constitution's separation of powers. The first was in 1868, when the House impeached President Andrew Johnson, who had succeeded Abraham Lincoln after his assassination at Ford's Theater. In firing the Secretary of War, President Johnson allegedly violated the Tenure of Office Act, which restricted the president's power to remove cabinet members during the term of the president who had appointed them. The House of Representatives approved articles charging him with conduct forbidden by law. That is an action that is an abuse of power on its face. Ultimately, the Senate acquitted President Johnson by 1 vote. This was partly because there was a strong argument that the Tenure of Office Act, which President Johnson was charged with violating, was itself unconstitutional, a position the Supreme Court later accepted. Of course, historians have also noted that a key senator appears to have changed his vote at the last minute in exchange for promises of special treatment by President Johnson. So perhaps that acquittal means a little less than meets the eye. In any event, just over 100 years later, the House Judiciary Committee accused a second chief executive of abusing his power in a manner egregiously inconsistent with the law. Now, the committee charged President Nixon with obstruction of Congress based on his meritless assertion of executive privilege to cover up key White House tape recordings. We will have more to say about the obstruction charge in a moment. But the Nixon case also exemplifies the second way a president can abuse his power. President Nixon faced 2 more articles of impeachment. Both of these articles charged him with abusing the powers of his office with corrupt intent. One focused on his abuse of power to obstruct law enforcement. The other targeted his abuse of power to target political opponents. Each article enumerated specific abuses by President Nixon, many of which involved the wrongful, corrupt exercise of presidential power, and many of which were likely not statutory crimes. In explaining its second article, the House Judiciary Committee stated that President Nixon's conduct was undertaken for his personal political advantage and not in furtherance of any valid national policy objective. That should sound familiar to everyone here. It reflects the standard I've already articulated: the exercise of official power to corruptly obtain a personal benefit while ignoring or injuring the national interest. To be sure, all presidents account to some extent for how their decisions in office may affect their political prospects. The Constitution does not forbid that. Elected officials can and should care about how voters will react to their decisions. They will often care about whether their decisions make it more likely that they will be reelected. But there is a difference that matters between political calculus and outright corruption. Some uses of presidential power are so outrageous, so obviously improper, that if they are undertaken for a president's own personal gain, with injury or indifference to core national interests, then they are obviously high crimes and misdemeanors. Otherwise, even the most egregious wrongdoing could be justified as disagreement over policy or politics, and corruption that would have shocked the framers, that they expressly sought to prohibit, would overcome the protections they established for our benefit. And there should be nothing surprising about impeaching a president for using his power with corrupt motives. The House and Senate have confirmed this point in prior impeachments. More important, the Constitution itself says that we can do so. To start, the Constitution requires that the president faithfully execute the law. A president who acts with corrupt motives, putting himself above country, has acted faithlessly, not faithfully executed the laws. Moreover, the 2 impeachable offenses that the Constitution enumerates, treason and bribery, each require proof of the president's mental state. For treason, he must have acted with a disloyal mind, according to the Supreme Court. And it is well established that the elements of bribery include corrupt motives. In sum, to the framers, it was dangerous for officials to exceed their constitutional power. But it was equally dangerous, perhaps more so, for officials to use their power with corrupt, nefarious motives, thus perverting public trust for private gain. Abuse of power is clearly an impeachable offense under the Constitution. To be honest, this should not be a controversial statement. I find it amazing that the president rejects it, yet he does. He insists that there is no such thing as impeachable abuse of power. This position is dead wrong. All prior impeachments considered of high office have always included abuse of power. All of the experts who testified before the House Judiciary Committee, including those called by the Republicans, agreed that abuse of power is a high crime and misdemeanor. Here is testimony from Professor Pam Karlan of Stanford Law School, joined by Professor Gerhardt.
Do scholars of impeachment generally agree that abuse of power is an impeachable offense?
Yes, they do.
Professor Gerhardt, do you agree that abuse of power is impeachable?
Yes, sir.
Professor Turley, who testified at Republican invitation, echoed that view. In fact, he not only agreed, but he, quote, stressed that it is possible to establish a case for impeachment based on a non-criminal allegation of abuse of power. Professor Turley is hardly the only legal expert to take that view. Another who comes to mind is Professor Alan Dershowitz, at least Alan Dershowitz in 1998. Back then, here is what he had to say about impeachment for abuse of power.
It certainly doesn't have to be a crime. If you have somebody who completely corrupts the office of president and who abuses trust and who poses great danger to our liberty, you don't need a technical crime.
But we need not look to 1998 to find one of President Trump's key allies espousing this view. Consider the comments of our current Attorney General, William Barr, a man known for his extraordinarily expansive view of executive power. In Attorney General Barr's view, as expressed about 18 months ago, presidents cannot be indicted or criminally investigated. But that's okay, because they can be impeached. That's the safeguard. And in an impeachment, Attorney General Barr added, the president is answerable for any abuses of discretion and may be held accountable under law for his misdeeds in office. In other words, Attorney General Barr, who believes, along with the Office of Legal Counsel, that a president may not be indicted, believes that that's okay. We don't need that safeguard against a president who would commit abuses of power. It's okay because he can be impeached. That's the safeguard for abuses of discretion and for his misdeeds in office. More recently, a group of the nation's leading constitutional scholars, ranging across the ideological spectrum from Harvard Law professor Larry Tribe to former Ronald Reagan Solicitor General Charles Fried, issued a statement affirming that, quote, abuse of power counts as an instance of impeachable high crimes and misdemeanors under the Constitution. They added, that was clearly the view of the Constitution's framers. I could go on, but you get the point. Everyone except President Trump and his lawyers agree that presidents can be impeached for abuse of power.
Everybody.
The president's position amounts to nothing but self-serving constitutional nonsense. And it is dangerous nonsense at that. A president who sees no limit on his power manifestly threatens the republic. The Constitution always matches power with constraint. That is true even of powers vested in the chief executive. Nobody is entitled to wield power under the Constitution if they ignore or betray the nation's interests to advance their own. President Nixon was wrong in asserting that, quote, when the president does it, that means it is not illegal. And President Trump was equally wrong when he declared that he had the right to do whatever I want as president. Under the Constitution, he is subject to impeachment and removal for abuse of power. And as we will prove, that is exactly what must happen here. Of course, President Trump's abuse of power, as charged in the first article of impeachment and supported by a mountain of evidence, is aggravated by another concern at the heart of the Constitution's impeachment clause: betrayal. The founders of our country were not fearful men. When they wrote our Constitution, they had only recently won a bloody war for independence.
Right.
But as they looked outward from their new nation, they saw kings scheming for power, promising fabulous wealth to spies and deserters. The United States could be enmeshed in such conspiracies. Foreign powers, warned Elbridge Gerry, will intermeddle in our affairs and spare no expense to influence them. The young republic might not survive a president who schemed with other nations, entangling himself in secret deals that harmed our democracy. That reality loomed over the impeachment debate in Philadelphia. Explaining why the Constitution required an impeachment option, Madison argued that the president might betray his trust to foreign powers. To be sure, the framers did not intend impeachment for genuine good faith disagreements between the president and Congress over matters of diplomacy. But they were explicit that betrayal of the nation through plots with foreign powers must result in removal from office. And no such betrayal scared them more than foreign interference in our democracy. In his farewell address, George Washington warned Americans, quote, to be constantly awake, since history and experience prove that foreign influence is one of the most baneful foes of Republican government, close quote. And in a letter to Thomas Jefferson, John Adams wrote, you are apprehensive of foreign interference, foreign intrigue, influence. So am I. But as often as elections happen, the danger of foreign influence recurs.
If you'll look at the very bottom there, pertaining to Mr. Thomas Jefferson, this letter was recognized December the 6th, 1787. Foreign influences. And there's no doubt that it's a tight walk line with presidencies that want to be influential with other leaders in other countries. It's a tight walk line in that balance of not becoming too friendly versus becoming influential. And the reason why that we sustain under the word influential is because we as Americans still remain in charge, still remain towards being the leader and not the one to be led. If you go to the extreme of giving in to these foreign powers, then you take a chance on not leading, but now you take a chance on being led. That is where the invisible line is drawn. That is where a president is not supposed to engage in. Once he engages in that type of behavior or that type of influence or that type of friendship, then is whenever he or she has crossed the line to the point that now we as a society over here in America can be held hostage to another country or another leader's will versus our own. And that's the whole purpose for putting these clauses in there, so that it will be recognized as being a big, big no-no. And I don't know if Donald Trump was being influenced by Mr. Putin of the old USSR pertaining to Russia. I don't know if he was being influenced in that area towards wanting to make things hard on the new Ukrainian government. But the thing about the Ukrainian government, it had already been pre-selected and established by our Congress, by our government, that they was in fact our allies. Keep in mind what they're accusing Donald Trump of doing. He withheld aid, precious aid, to an ally that at that time should not have been held, but should have went ahead with the aid. He committed an illegal act by stopping this aid without going through Congress. A president is not supposed to be able to do that. Not only did he do that, according to what I understand, but he done that in the pretense towards trying to persuade or blackmail the president, the new president of the Ukrainian government, to get dirt on his rival, on his competition, which is Joe Biden. That's a double no-no. Now you're going to get another country to come in and avert and engage in their ideals, in their thoughts, in their wants, in their likes or dislikes pertaining to our own political, presidential affairs under a free, fair, open election? How much wronger can you get if what the president's being accused of fares to be true? These are serious offenses of the impeachment on the trial of Donald Trump, our current President of the United States of America.
The framers never suggested that the president's role in foreign affairs should prevent Congress from impeaching him for treachery in his dealings. Case in point, they wrote a constitution that gives Congress extensive responsibility over foreign affairs, Congress, including the power to declare war, regulate foreign commerce, establish uniform rule of naturalization, and define offenses against the law of nations.
Treachery!
Contrary to the claims you heard the other day that the president has plenary authority in foreign affairs and there is nothing Congress can do about it, the Supreme Court has stated that constitutional authority over the conduct of the foreign relations of our government is shared between the executive and legislative branches. Or to quote another Supreme Court case, the executive is not free from the ordinary controls and checks of Congress merely because foreign affairs are at issue. In these realms, Justice Jackson wrote, the Constitution enjoins upon its branches separateness but interdependence, autonomy but reciprocity. Where the president betrays our national security and foreign policy interests for his own personal gain, he is unquestionably subject to impeachment and removal. The same is true of a different concern raised by the framers, the use of presidential power to corrupt the elections and the office of the presidency. The framers were no strangers to corruption. They understood that corruption had broken Rome, debased Britain, and threatened America. They saw no shortage of threats to the Republic and fought valiantly to guard against them. But as one scholar writes, the big fear underlying all the small fears was whether they'd be able to control corruption. So the framers attempted to build a government in which officials would not use public power for personal benefits, disregarding the public good in pursuit of their own advancement. This principle applied with special force to the presidency. As Madison emphasized, because the presidency was to be administered by a single man, his corruption might be fatal to the republic. Indeed, no fewer than 4 delegates to the Constitutional Convention, Madison, plus Morris, Mason, and Randolph, listed corruption as a central reason why presidents must be subject to impeachment and removal from office. Impeachment was seen as especially necessary for presidential conduct corrupting our system of political self-government. The framers foresaw and feared that a president might someday place his personal interest in re-election above our abiding commitment to democracy. Such a president, in their view, would need to be removed from office. Professor Feldman made this point in his testimony before the House Judiciary Committee.
The framers reserved impeachment for situations where the president abused his office, that is, used it for his personal advantage, and in particular, they were specifically worried about a situation where the president used his office to facilitate corruptly his own re-election. That's in fact why they thought they needed impeachment and why waiting for the next election wasn't good enough.
Professor Feldman's testimony is grounded in the records of the Constitutional Convention. There, William Davey warned that a president who abused his office might spare no efforts or means whatever to get himself reelected, and thus to escape justice. George Mason built on Davey's position, asking, "Shall the man who has practiced corruption, and by that means procured his appointment in the first instance, be suffered to escape punishment by repeating his guilt?" Mason's concern was straightforward. He feared that presidents would win election by improperly influencing members of the Electoral College. Governor Morris later echoed this point, urging that the executive ought therefore to be impeachable for corrupting his electors. Taken together, these debates demonstrate an essential point. The framers knew that a president who abused power to manipulate elections presented the greatest possible threat to the Constitution. After all, the beating heart of the Framers Project was a commitment to popular sovereignty. At a time when democratic self-government existed almost nowhere on earth, the framers imagined a society where power flowed from and returned to the people. That is why the president and members of Congress must stand before the public for re-election on fixed terms. And if a president abuses his power to corrupt those elections, he threatens the entire system. As Professor Carlin explained in her testimony,
drawing a foreign government into our elections is an especially serious abuse of power because it undermines democracy itself. Our Constitution begins with the words, "We the people," for a reason. Our government, in James Madison's words, derives all its powers directly or indirectly from the great body of the people. And the way it derives these powers is through elections. Elections matter, both to the legitimacy of our government and to all of our individual freedoms, because as the Supreme Court declared more than a century ago, voting is preservative of all rights.
Professor Carlin is right. Elections matter. They make our government legitimate, and they protect our freedom. A president who abuses his power in order to kneecap political opponents and spread Russian conspiracy theories, a president who uses his office to ask for, or even worse, to compel foreign nations to meddle in our elections, is a president who attacks the very foundation of our liberty. That is a grave abuse of power. It is an unprecedented betrayal of the national interest. It is a shocking corruption of the election process. And it is without doubt a crime against the Constitution, warranting, demanding removal from office. The framers expected that free elections would be the usual means of protecting our freedoms. But they knew that a president who sought foreign assistance in his campaign must be removed from office before he could steal the next election. In a last-ditch legal defense of their client, the president's lawyers argue that impeachment and removal are subject to statutory crimes or to offenses against established law, that the president cannot be impeached because he has not committed a crime. This view is completely wrong. It has no support in constitutional text and structure, original meaning, congressional precedents, common sense, or the consensus of credible experts. In other words, it conflicts with every relevant consideration.
Listen to what he just said. I'm going to back this up. I want you to listen to the different categories that he's putting this off into.
Professor Garrett. This view is completely wrong. It has no support in constitutional text and structure, original meaning, congressional precedents, common sense, or the consensus of credible experts. In other words, it conflicts with every relevant consideration.
Every.
Professor Gerhard succinctly captured the consensus view in his testimony.
Professor Gerhard, does a high crime and misdemeanor require an actual statutory crime?
No, it plainly does not. Everything we know about the history of impeachment reinforces the conclusion that impeachable offenses do not have to be crimes, and again, not all crimes are impeachable offenses. We look at the context and gravity of the misconduct.
This position was echoed by the Republicans' expert witness, Professor Turley, in his written testimony. There he stated that, it is possible to establish a case for impeachment based on a non-criminal allegation of abuse of power. He also stated, it is clear that high crimes and misdemeanors can encompass non-criminal conduct. More recently, Professor Turley, again the Republican witness at our hearing, wrote an opinion piece in the Washington Post entitled, Where the Trump Defense Goes Too Far. In this piece, he stated that the president's argument is as politically unwise as it is constitutionally short-sighted. He added, if successful, it would also come at a considerable cost for the Constitution. Although I disagree with Professor Turley on many, many issues, here he is clearly right. And I might say the same thing of then House Manager Lindsey Graham, who in President Clinton's trial flatly rejected the notion that impeachable offenses are limited to violations of established law. Here is what he said.
What's a high crime? How about if an important person hurts somebody of low means? It's not very scholarly, but I think it's the truth. I think that's what they meant by high crimes. Doesn't even have to be a crime. It's just when you start using your office and you're acting in a way that hurts people, you've committed a high crime.
There are many reasons why high crimes and misdemeanors are not and cannot be limited to violations of the criminal code. We address them at length in the briefs we have filed and the report of the House Judiciary Committee respecting these articles of impeachment. But I would like to highlight a few especially important considerations. I'll tick through them quickly. First, there is the matter of the historical record. The framers could not have meant to limit impeachment to statutory crimes. Presidents are to be impeached and removed from office for treason, bribery, and other high crimes and misdemeanors. But bribery was not made a statutory crime until 1837. Second, the president's position is contradicted by the Constitution's text. The framers repeatedly referred to crimes, offenses, and punishment elsewhere in the Constitution. But here they refer to high crimes. That matters. It matters because the phrase high crimes refers to offenses against the state rather than to workaday crimes. And it matters because the phrase high crimes and misdemeanors had a rich history in England where it had been applied in many, many cases, that did not involve crimes under British law. When the framers added high crimes here, but nowhere else in the Constitution, they made a deliberate choice. Any doubt on that score is dispelled by the framers' own statements. In Federalist Number 65, Alexander Hamilton explained that impeachable offenses are defined fundamentally by the abuse or violation of some public trust. A few years later, James Wilson, the Constitutional Convention delegate, agreed with Hamilton. Wilson stated, impeachments and offenses and offenders impeachable come not within the sphere of ordinary jurisprudence. They are founded on different principles, are governed by different maxims, and are directed to different objects. George Mason expressed concern that the president might abuse the pardon power to, quote, screen from punishment those whom he had secretly instigated to commit a crime, and thereby prevent a discovery of his own guilt. Sound familiar? James Madison responded directly to Mason's concern, because Mason's concern was that the pardon power might be too broad. The president might misuse his broad pardon power to pardon his own co-conspirators and prevent the discovery of his own guilt. Madison responded, if the president be connected in any suspicious manner with any person, and there be grounds to believe he will shelter him, the House of Representatives can impeach him. They can remove him if found guilty. At the North Carolina ratifying convention, James Iredell, who would go on to serve on the Supreme Court, responded to the same concern. He assured delegates that if the president abused his power with, quote, some corrupt motive or other, he would be liable to impeachment. In the early 1800s, this understanding was echoed by Supreme Court Justice Story, who wrote his famous treatise on the Constitution. There he rejected the equation of crimes and impeachable offenses, which he stated must be examined upon very broad and comprehensive principles of public policy and duty. Later in American history, Chief Justice and former President William Howard Taft, as well as Chief Justice Charles Evans Hughes, publicly stated that impeachable offenses are not limited to crimes, but instead capture a broader range of misconduct. Indeed, under Chief Justice Taft, the Supreme Court unanimously observed that abuse of the president's pardon power to frustrate the enforcement of court orders would suggest resort to impeachment. And this is square. Now notice, pardon power is unlimited. What they're saying here is abuse of the pardon power, use of the pardon power for corrupt motive was impeachable. And if all that authority is not enough to convince you, there is more. Historians have shown that American colonists before the Revolution and American states after the Revolution, but before 1787, all impeached officials for non-criminal conduct. Over the past 2 centuries, moreover, a strong majority of the impeachments voted by the House have included one or more allegations that did not charge a violation of criminal law. Indeed, the Senate has convicted and removed multiple judges on non-criminal grounds. Judge Archibald was removed in 1912 for non-criminal speculation in coal properties. Judge Ritter was removed in 1936 for the non-criminal offense of bringing his court into scandal and disrepute. During Judge Ritter's case, one of my predecessors as chairman of the House Judiciary Committee stated expressly, "We do not assume the responsibility of proving that the respondent is guilty of a crime, as that term is known to criminal jurisprudence." What is true for judges is also true for presidents, at least on this point. The House Judiciary Committee approved 3 articles of impeachment against President Nixon. Each of them encompassed many acts that did not violate federal law. One of the articles, obstruction of Congress, involved no allegations of any legal violation. And it is worth reflecting on why President Nixon was forced to resign. Most Americans are familiar with the story. The House Judiciary Committee approved articles of impeachment in July 1974. Those articles passed with bipartisan support, although most Republicans stood by President Nixon. Then the smoking tape came out. Within a week, almost everyone who supported the president a week before changed his position, and the president was forced to resign because of what was revealed on the smoking gun tape. Within a week, Senator Goldwater and others from the Senate went to the president and said, "You won't have a single vote in the Senate. You must resign or you will be removed from office," because of the evidence on the smoking gun tape. But what was on the smoking gun tape? The smoking gun tape were recordings of President Nixon instructing White House officials to pressure the CIA and the FBI to end the Watergate investigation. No law explicitly prohibited that conversation. It was not in that sense a crime. But President Nixon had abused his power. He had tried to use two government agencies, the FBI and the CIA, for his personal benefit. His impeachment and removal was certain, and he announced his resignation within days. Decades later, in President Clinton's case, the Judiciary Committee reported on the articles of impeachment stated, "The actions of President Clinton do not have to rise to the level of violating the federal statute regarding obstruction of justice in order to justify impeachment." There is thus overwhelming authority against restricting impeachments to violations of established or statutory law. Every relevant principle of constitutional law compels that result. So does common sense. Impeachment is not a punishment for crimes. Impeachment exists to address threats to the political system, applies only to political officials, and responds not by imprisonment or fines, but only by stripping political power. It would make no sense to say that a president who engages in horrific abuses must be allowed to remain in office unless Congress had anticipated his or her specific conduct in advance and written a statute expressly outlawing it. For one thing, that would be practically impossible. As Justice Story observed, the threats posed by presidential abuse are of so various and complex a character that it would be almost absurd to attempt a comprehensive list. The Constitution is not a suicide pact. It does not leave us stuck with presidents who abuse their power in unforeseen ways that threaten our security and democracy. Until recently, it did not occur to me that our president would call a foreign leader and demand a sham investigation meant to kneecap his political opponents, all in exchange for releasing vital military aid that the president was already required by law to provide. No one anticipated that a president would stoop to this misconduct, and Congress has passed no specific law to make this behavior a crime. Yet this is precisely the kind of abuse that the framers had in mind when they wrote the impeachment clause. And when they charged Congress with determining when the president's conduct was so clearly wrong, so definitely beyond the pale, so threatening to the constitutional order as to require his removal. And that is why we are here today. You must judge for yourselves whether justice will be had for President Trump's crimes against our freedom and the Constitution. I will conclude by highlighting a few points that merit special emphasis as you apply the law of impeachment to President Trump's misconduct. First, impeachment is not for petty offenses. The president's conduct must constitute, as Mason put it, a great and dangerous offense against the nation, offenses that threaten the Constitution. Second, impeachable offenses involve wrongdoing that reveal the president as a continuing threat if he is allowed to remain in office. In other words, we fully recognize that impeachment does not exist for a mistake. It does not apply to acts that are merely unwise or unpopular. Impeachment is reserved for deliberate decisions by the president to embark on a course of conduct that betrays his oath of office and does violence to the Constitution. When the president has engaged in such conduct, and when there is strong evidence that he will do so again, when he has told us he'll do so again, when he has told us that it's okay to invite interference from a foreign power into our next election, the case for removal is at its peak. This is certainly the case when he invites, indeed attempts to compel, a foreign government to help him subvert the integrity of our next election. There can be no greater threat to the Republic. Finally, high crimes and misdemeanors involve conduct that is recognizably wrong to a reasonable, honorable citizen. The framers adopted a standard for impeachment that could stand the test of time. At the same time, the structure of the Constitution implies that impeachable offenses should not come as a surprise. Impeachment is aimed at presidents who act as if they are above the law, at presidents who believe their own interests are more important than those of the nation, and thus at presidents who ignore right and wrong in pursuit of their own gain. Abuse, betrayal, corruption. Here are each of the core offenses the framers feared most. The president's abuse of power, his betrayal of the national interest, and his corruption of our elections plainly qualify as great and dangerous offenses. President Trump has made clear in word and deed that he will persist in such conduct if he is not removed from power. He poses a continuing threat to our nation, to the integrity of our elections, to our democratic order. He must not remain in power one moment longer.
In other words, what they're saying is he's trying to be so clever and sneaky that he's trying to manipulate or deceive the people by hiding it in plain view. By, I guess, standing under the guidelines of ignorance, acting ignorant pertaining to our laws. And that is one of the first things that any judge would tell you if anybody stands up there. It doesn't matter if it's involving a traffic violation or somebody that killed somebody. If they're stupid enough to stand in the courtroom and say, well, Your Honor, I didn't know that it wasn't okay to drive 45 mile an hour in a 15 mile an hour school zone. Or I didn't see the sign, or I didn't know that I wasn't supposed to have killed that person or stolen whatever it was that you was being accused of stealing. And most judges will look at you that in the court of law, ignorance is no excuse. Ignorance is no excuse. So to try to openly plea out on the law of insanity towards not being known of what you're doing is wrong, or towards doing it continuously thinking that isn't nobody going to notice or see you doing it, it just shows a lack of integrity and imbalancement with Donald J. Trump to the degree that he's trying to play the American people off for a bunch of fools. Come on. There comes a time to where even a blind man can see. And if people can't see what has occurred here towards Donald Trump stopping the aid to a precious ally of ours that was engaged in warfare against the Russians, if people can't see through this, obviously they're blinder than a blind person. That puts us right where the Bible says that if the blind lead the blind, they both shall leadeth off into the ditch. Donald J. Trump was the one that was leading the rest of the blind into the ditch, hoping it wouldn't nobody open their eyes up to realize that what is occurring here is wrong. It's wrong from an ethnic standpoint, it's wrong from a legal standpoint, and it's wrong from a moral standpoint. I have said all along that whenever you're dealing with a society that is so upside down, it's almost as if trying to vote someone off the island, and the one that you're trying to get off the island is the one that owns the island. That's basically what I've been going up against for the past 30 years, of a group of people around here that claimed that they had some sort of a religious relationship with the Maker, of reading out of the same Bible that I have read out of since I was just a child growing up. But yet, no, I didn't have no confidants, I didn't have no friends, and I didn't have no people that actually supported the Windmill Ministries movement. Now, they'll tell you that, oh yeah, we want peace. Really? Do you want peace? But yet now you continue to do the same thing again and again and again. Once more, trying to do like Donald Trump, trying to disguise what you're doing in broad view. It's very obvious the churches around here didn't want true peace. Because if they did, they would have dug a little deeper. They would have thought a little harder. They would have read a little longer. They would have studied a little more in depth pertaining to what the individual is talking about that's talking right now to my viewers pertaining to all this. It kind of works hand in hand, even though Donald Trump is on a political platform. I myself am on a spiritual platform. But if you'll narrow it down to the things that Donald Trump was trying to do in plain view versus the people around here that was trying to do in plain view, it's pretty obvious what was going on. It's not that it didn't happen. Now the next question is, why did it happen? Was it because that they was just a bunch of cowards? Was it simply because they was fraudulent in their relationships with God to the point that none of them wanted to see biblical Bible prophecy fulfill itself? In other words, they was all devils in disguise? Or was it based around ignorance and the fact that they had been taught incorrectly about acknowledging and accepting biblical Bible prophecy? I just know what the teachings of Christ said. Jesus said that in the last days that they would come in sheep's clothing, but inwardly would be raging wolves. And I just know that Jesus Christ in his teachings said, let it be known in their law, the law of the wicked, the law of the demonic, the law of the world, the law of the political structure. Let it be known in their law, for they hated me, according to Jesus, in Jesus' teachings, for they hated me for no cause. Why has these people turned their backs on me the way that they have? Why have these people not acknowledged the message coming from the messenger towards it being authentic? It's not nothing that I have personally done to any of these people. So it has to be a deeper hidden agenda. Other than that, it's the fact that they have been bamboozled. They have been deceived. They have been hoodwinked. And now all of a sudden the same individual that they had buried years and years ago towards disgracing his name, towards degrading him and demonizing him and dehumanizing him. Now all of a sudden this same individual comes back and says, well, let's look at the big picture now. Towards $23 trillion in debt. Over 2.3 incarcerated prisoners either in prison or inmates in jail. Let's look at all the corruption throughout all the other churches. And let's look at our neighborhoods, how that it's been infested with drugs and all our jobs that has basically went south. all our empty factories, all our deserted churches, church buildings that are now left vacant. And it's not that the individual that's talking to you right now is trying to say 90-90 boo-boo, but it's the fact of the matter is, as my grandmother used to preach to all us boys, that if the shoe fits, wear it. It's pretty obvious that these people around here don't want to wear it. They don't want to walk around with egg on their face. In which that's understandable. Neither nor does Donald Trump. But when you're busted, you're busted. Because if it looks like a duck, quacks like a duck, sounds like a duck, odds are it's probably a duck. There isn't no other way to smear it. There isn't no other way to distort it. There isn't no other way to manipulate it. There isn't no other way to try to shade it into another category other than it being a duck. If it looks like a duck, quacks like a duck, walks like a duck, odds are it's probably a duck. Now, how come that is so difficult for the people in this area to comprehend? If I can comprehend it with an undergraduate degree, and if others can comprehend it, how come they cannot comprehend it? And it goes the same way towards Donald J. Trump. If others can comprehend towards what that he has done, how come he is still like O.J. Simpson in denial that if the glove does not fit, we must acquit? And of course, we see what occurred in that scenario, going all the way back to when it first originated with the O.J. Simpson trial. I have never been so heartbroken over the abusiveness of common sense that has occurred here in America since the beginning phases of the 80s, since Ronald Reagan and the Bushes come into power, that has put this country in peril. I have never seen so much distortedness, so much confusion, so much backbiting and disrespectfulness with the church communities as I have in the past 30 plus years. That even to this day, they're still standing firm, even though the ship is going down, and it's going down fast, pertaining to all this indebtedness and all these problems that has recently surfaced. Even though we're going down, no one wants to admit towards any fault of why we're going down. I have never seen such of a scalded society in their hypocrisy in not acknowledging their wrongdoings. And to be quite frank with you, getting off of all of that towards what is occurring right here, I have found it, even though it has come in a raw, bad way, but I have found a lot of these hearings, and beginning with these trials, to be absolutely some of the most educational historical history lessons that any teacher in elementary school or high school up here in Sharon, Tennessee could have ever elaborated on, to the degree that now I know more about this country and about who sacrificed for this country and who put in order of the rules pertaining to this country. I know more today pertaining to all this stuff that has happened. If there is a silver lining, this is it. I have learned more history in the past 6 months since all this has developed on TV than I think that I could have ever studied in history books going to school. I didn't know about all these speeches and all these things that was said. Regrettably, I wish that I could have been in school. But under the circumstances towards an abusive father, being in an abusive relationship, having to be reared up on a farm, pertaining to such idiotic behavior that was going on in this area, I couldn't take the time to learn as other children learned that went on ahead of me, that become great successes in some form or fashion in their businesses or towards being loyalty in their loyalty to other businesses. I wish that I could have, and I really don't have no one to blame for that but myself, even though that dark hand was forced upon to my family the way that it was. I should have went ahead and pursued my educational career after that I broke away from being subjected to that type of abuse, and I have no one to blame for that other than myself, because I didn't further educate myself in historical history matters of what has occurred in the great development of one of the greatest nations upon to this planet, which is America. We're going to leave this at that. It was very sombering in hearing what he had to say and the way that he had to say it. And I don't want to mix bag this to the point of stuffing too much information to my viewers, to the point that they get it confused towards what this one was saying versus that one. I think the people can understand the laws of impeachment and why that they was put in place to protect the benefit of the Union. Whenever we pledge allegiance, we're not just pledging allegiance to a ideology like a tooth fairy or an ideology of the Easter Bunny. When we pledge allegiance, we're pledging allegiance to an established body that was brought together by God and man in the fairness of both. The fairness of not only the godly, but also the ungodly. Not that the ungodly was to rule over the godly or the godly over the ungodly per se, because everybody's got their fair say. Everybody's got their fair choice of whether or not they want to serve God or not serve God. Everybody's got their fair choice of whether or not they want to be obedient to the laws of the land towards being a good subservient unto society, or they want to just be an out-and-out criminal. an outlaw. We all have the same choices. We growed up, some of us in much different circumstances, some better than others. But no one held a gun to any of our heads and said, this is what you're going to do. Like they do over in Russia or in China or in other communist-controlled countries. These are our choices. This is our established government. And it is, in fact, one of the greatest established governments on the planet. On the planet. Whenever they gave pledge to allegiance, as you listen to the end part of that, liberty and justice for all. Not just to the rich, not just to the smart, not just to the ones who was gifted towards being brought up in the right education, with the right family, with the right discipline, with the right teachers, with the right influences, with the right money, but even to the poorest of the poor, of the uneducated of the uneducatedest, to those who was the healthiest of the healthy, to the sickest of the sick, to all, A-L-L. It's the same thing that Jesus taught in his teachings, that who, which means all, whosoever calleth upon the name of the Lord shall be saved. Not whatsoever, but whosoever, indicating the fairness of all colors, of all races, of all genders, of all people. Big, little, rich, poor, smart, uneducated, of all races. This has been a enlightening, educational time for me personally to sit and listen to all these experts pertaining to historical events that has happened, that has brought this great nation into existence. But at the same time, it's also been a very, very sadful, remorseful time to think that we have had a president that thought that he could basically pull the wool over the American people's eyes. Undermining not only the people, but undermining the Constitution that the people serves under. So in ways, I hope that it's been an experience, an educational experience for the vast majority of us, of sitting and listening to various experts about this and about that, and about what this one said, and what this one meant, and what this one was going through during the time that he or she was going through what they was going through, to help to manufacture this machine that we call free, fair, open democracy. 2 thumbs up. 2 thumbs up towards bringing this into transparency so that now we, the people, can make our own desirable conscience decisions towards what has occurred here in the past few weeks, in the past few months, pertaining to the impeachment trial of Mr. Donald J. Trump.